Good morning. Please be seated. Council, I'll begin with some apologies. I apologize. The courtroom is stuffy. Our air conditioning system is out, and they tell us, don't worry about it, it'll be fixed by July. So the new courthouse across the street will probably be ready before it will. But anyway, if you hear some noise in the background, we have a couple of fans going back here, and I hope that's not distracting to you. We have one matter scheduled on the docket this morning. It is cause number 0721-00278CV in the interest of A.G., a child, here today for the appellant. Mr. Sharpie, are you ready to proceed?
Ready to proceed.
And for the state, Ms. How do you pronounce that? Savavi? Ms. Savavi, are you ready to proceed? Ms. Savavi, I want to take a moment just to thank you for being here. I know you had a difficult time getting here, and you kept the court apprised of your travels, and I appreciate that. It's always good to know if there's any problems, but we really do appreciate you being here today and presenting oral arguments. As you may or may not know, Mr. Sharpie, I know, is arguing before this court. Appellant will have 20 minutes for opening, and appellee will have 20 minutes in response, and then appellant will have a 5-minute rebuttal. Mr. Sharpie, if you're ready to proceed.
Ready. May it please the court, counsel. We have before us today a parental termination case. I was appointed to represent the father on the appeal of this case. There were 4 issues which were raised on appeal. The first, and perhaps the most interesting to me, is the denial of a motion for extension under 264-104, I believe is the statute, or actually 263-401, in which my client asked for additional time to complete his services. That was denied. The second issue was the termination under E. We allege that there was no evidence to support termination on that basis, in that while Dad did test positive for methamphetamine during the pendency of the case, the child had been removed, and therefore there was no evidence that his conduct endangered or did anything to hurt the child. The next issue was with regard to whether there was sufficient evidence on the best interest of the child.
Mr. Sharpie, I apologize. I have not had time to read the record. I've read the briefs, but not the record. Was the father living with the mother at the time of birth?
Yeah, let me give you the timeline, Justice Parental, because it's significant to the case. What happened here was the mother and father started a relationship in November of 2019. The mother became pregnant in February of 2020. Sometime after the pregnancy was announced, the mother and the father separated. The child was born on or at or near September 15th, 2020. She was removed from the mother at birth at the hospital because the mother had tested positive for methamphetamine during her prenatal care. Had history with CPS as well, so the child was immediately removed.
And father also had a history with the department in March of 2020, right? That's
correct. He had other children, and the department had started an investigation with regard to those children. He had supervised visitation with at least one of them, pursuant to notice.
And that was also for his use of methamphetamine?
Yes, it was, Your Honor. Yes, it was. So, the case is initiated. As part of the case, a paternity action is included, because father is not a presumed dad. They weren't married. There was a short-term relationship, so his paternity needed to be established. There was DNA testing, and the father finds out about the paternity sometime in January of 2021. At that point, the trial court appoints an attorney to represent the father on January 22nd of 2021. Until then, he had been unrepresented. He had not been working his services. He had not been participating. Right or wrong, he wanted to know whether he was the father before he initiated all that. The case then, he begins to work services at that point. I think the record demonstrates that he completed his rational behavior training on March 11th of 2021. He completed his psychological examination on March 5th of 2021. He completed his OSAR evaluation on March 3rd of 2021. And he completed his counseling on April 20th, 2021. He had failed drug tests up until that point. He'd either not shown, or the ones he took, he was testing positive for methamphetamine. We get to...
To your timeline, can we back up and
Yes.
add that he signed his plan of service, apparently from the record evidence, in December of 20... Is that...
I believe that's correct, Your Honor. I think they initiated that. The paternity results came back in December.
Right.
His testimony was, I really didn't know about it till January, but it would, I don't have it in front of me, but it would stand to reason that, yeah, he probably signed off on the service plan once his paternity was established.
If he signed off on his service plan, doesn't his signature constitute some evidence that he at least knew at that point that he was the father? I mean, without regard to when he says he got his paternity results.
You know, Justice, I don't know whether I would go so far as to say that means he knows he's the father. He certainly was aware of the services he needed to work if he was the father and he wanted to return to the child. You know, the service plan, he acknowledges that he has to work these services or his rights could be terminated.
I think, I'm trying to make sure I understand the record right. You said, though, he did not begin his services until March?
That's correct, Your Honor. I mean, the testimony was that he, well, and actually whether he started them or not, that's when he completed the ones that he did complete.
How much overlap would there have been, if any, with any kind of service plan with the other children?
You know, I'm not aware of that, Your Honor. There wasn't much testimony in the record about that, and whether he had worked services in another plan or not is not in the record that I'm aware of. Ms. Safi may have a different opinion on that, but as far as I'm concerned, that was a different matter and not really addressed.
Well, what would be the extraordinary circumstances that he would be, that would have entitled him to an extension?
As I'll continue on to get to that point, if I may, Justice Parker, the order, if you look at the record, you have the drug test that he either didn't take or failed, okay? Then the big issue was he did
And that
not...
would have been pursuant to the service, the plan of service that he signed in December?
Yes, ma'am. Yes, ma'am. Then the central issue, or what appeared at least for me from the record, was he did not complete inpatient drug treatment at Cencor, and he did not complete the Padre program, which is a counseling type situation where they help parents that have drugs and how it affects their children, and a counseling type program called Padre.
Does the record indicate when he began his inpatient treatment?
Well, let me put it this way. The order signed by the trial court requiring Padre and Cencor was not signed until March 22nd of 2021. There is some testimony that he had begun inpatient treatment at Serenity House. I'm not real clear on the date, but it's also clear he walked out 6 days later.
Yeah, he wasn't there very long, right?
No,
Well, I can't tell from the record, but is Centacor and Serenity House, are
Well,
those related?
you know, I don't know the answer to that for sure, Justice Parker, but I think they're two different inpatient rehabilitation.
But there's nothing to suggest that Serenity House would not have been acceptable under the plan had he stayed.
It probably would have been. I don't think the department, you know, I may be speaking out of turn, but the point was obviously for him to get inpatient drug treatment. He did attempt that at some point, probably in the March time period, I think.
Yeah, I was assuming that from as you mentioned, the date of the ordered services, the permanency hearing that occurred about that time, and then that'd be about right.
Do we know if that was before or after the order got signed? Because I think the order got signed the same month, right?
Yeah, you know, I'm not real clear on the timing of when he did that. I don't know if he did that before or after. but I think for purposes of the argument about whether there were extraordinary circumstances, which would have made it an abuse of discretion to not grant the extension, for my purposes, the order, that time period should start March 22nd, 2021, when there's a signed order by a judge telling him this is what you have to do. So, from that point forward, father's testimony was that he had stopped using drugs sometime in April or May of 2021. He had a clean UA in July of 2022. April or May of 2022. He had a clean UA in July of 2022, but his hair follicle was still hot. We have the final trial on September 13th, 2022. So on the first issue,
When was the final judgment signed? Or the termination?
the final judgment there was a de novo, and that was done on November 13th, 2022, 30 days after the original associate judge had the trial.
So for purposes of working the plan and for going into one of these inpatient programs, he had about a year and a half, I guess?
Well, from my perspective, Justice Doss, he had from the time the order was entered requiring him to complete that service. We don't really have it briefed in this one. I'm sure the court's aware of all the authority out there about there has to be a signed court order requiring the parent, telling them exactly what they have to do, where they got to do it, all that type of stuff.
And I apologize. I think I misunderstood the answer you had for when the order of termination was signed. It was November of 21.
Oh, I'm sorry, 22. 21. I'm sorry.
That's the part where I was like, it was a year and a half, but we
I'm
obviously
getting
we can't consider time travel yet.
I
So
guess that's my.
it was about 8 months, I guess.
Yes, that's right. So we have basically, assuming that April, May, June, July, August, and then we have the trial.
Okay.
So I say he's got 5 months to get all that done. And he did, with the exception of the drug test that I'm sure CPS will talk about, but all the other services with the exception of the Senecor and the Padre. So what was the deal there? According to the testimony, my client takes a full-time job in May, okay? They asked him, why didn't you try to get off work? Why didn't you do something so you could go into a 30-day inpatient rehab program? His testimony and the argument is, I have a full-time job, okay? Part of the service plan is you have to maintain employment. That's one of the conditions. The other condition is you got to go to inpatient rehab. So you're kind of putting the guy in a catch-22.
Well, but let's be fair.
Sure.
He was in inpatient drug treatment for a 15-year methamphetamine problem,
Yes, ma'am.
and he walked out
That's
after
correct.
5 or 6 days, and then got other employment, right? So he had an opportunity to do it.
To be fair, he had from March till May before he had the job that he could have gone in March or in April and got it done.
Is there anything in the record that he reached out to the department to say, hey, I've got a new job, they're requiring me to be here during this time, is there a way we can do this on
Yes.
a different basis? What do those records say?
He testified that he had talked to CPS, he called, I can't remember the name of the person that was in charge of the program, asked if there's some way he could do it remotely, if there's some way he could do it in the evening, and he was told no. It just wasn't a possibility. Now,
Let me ask you this, though. I want to make sure I understand the way this lines up with the drug tests. He still had a hot hair follicle test in July. Did he have a dirty UA in April?
I don't think there was a drug test in April. The record is, from the record, it looks to me like when it first started, there was testimony from CPS that he'd failed to appear at about 4 tests, so obviously those were considered positive.
Sure.
I think there were drug tests. I don't know if there was a drug test in April, to be honest with you. I don't
He
think...
did admit, though, the record evidence at trial before the associate judge was that he admitted to use either, I think it was April or May.
Yes, his testimony was that he had stopped using April or May, and obviously the implication is he hadn't before then.
Well, and that also doesn't that discount his explanation of, I would have gone into rehab but for my job? If he still has dirty drug tests during this time, that might mitigate against that, the effectiveness of that argument.
Certainly not. The argument is that he had a clean UA. He had a dirty hair follicle. Of course, the hair follicle goes back 3 months. So if we're talking about taking one in July, then if he'd used in June, or he'd used in May, or he'd used in April, it would show up in the hair follicle. So I think the July test kind of jives with his testimony. Yeah, 3 months ago, I was still using. So the hair follicle's dirty. But
What
the
about
UA is not.
what about the presumptive dirty UAs because he didn't show up for the other test? Doesn't that, I mean, that seems like,
Yeah.
if he's got a clean test, that would be his opportunity to do it.
Certainly. There's no question that his failure to appear, as far as the court's concerned, as far as the law is concerned, those are dirty tests. We're not trying to sit here and say, because he didn't take the test, they can't prove he was using drugs. Really, the argument comes down to, as Justice Parker points out, in order to grant the extension, there has to be extraordinary circumstances. It's got to be in the best interest of the child.
Where is the record evidence about the, that it would be in the child's best interest and the focus on the child that's required under that section?
And typically, what that turns on is the permanency argument. We need this child to be, it's in a placement that's looking at adoption. We need some permanency to this. We need to get this over with so the child can move on with his life. In this particular case, the only testimony about the child was there was a relative that was maybe looking to do some visitation, to maybe consider placement. And it's kind of a far from the record, but you're dealing with a methamphetamine baby here that has a lot of problems, is not a good candidacy probably for adoption because of all these, Lord knows what kind of problems this child's going to have. So my argument is there is not the usual testimony of this child's been in placement for a year now, these people are waiting to adopt the child, it's not in the best interest of the child to continue this. Because the status of the child is still in flux, and given the parental presumption and the constitutional rights and the overwhelming desire of the courts and the law to reunite with the parent, if that child is still in flux, they can't say it's in the best interest of the child to necessarily deny the extension.
Well, I understand you are not trial counsel, but there appears to be a lack of evidence with regard to the child's needs or the best interest focus at this stage when the court was presented with the motion for extension. Let me ask you this. Was father required to re-urge his motion for extension before the referring court at the de novo hearing in order to preserve it for appellate review?
All I can tell you is I don't know, Justice Parker. I don't know.
Well, I don't know either.
Yeah,
but I thought I'd ask.
I don't know. It would seem to be pointless at that point because there's already been an order of termination. And
Well, no, there wasn't, because the associate judge didn't terminate.
Right.
The associate judge
That's true.
appointed the father, I believe, as a possessory
Possessory conservator, made the department
But all the issues were back in play at the de novo hearing. So that's why I was asking whether you should have.
It could be, and if the court wants additional briefing on that, I'm sure we're happy to provide that, but I don't have the answer for that today, Justice.
You also mentioned that on ground E,
Yes.
his drug use was not
Endangering conduct.
endangering conduct. Well, let me ask you about that.
Yeah.
Because the testimony appears to suggest that there's a dirty UA in the record, I think February the 24th this is after he signed his service plan, before the court ordered him to go to inpatient drug treatment. And at the initial permanency hearing order, after he'd filed his answer and appeared, the associate judge restricted and provided no visitation with the child pending a clean UA. So it would the record further indicates that he didn't even visit with the child until July the 26th. So couldn't an argument be made that his drug use during the course of the pendency of this suit prevented him from bonding with the child and providing emotional and physical support of the child?
Yes, Justice, I'm sure that's what CPS is going to argue. Well, from my perspective, and I cite the cases in the brief where there's kind of been a shift, in my opinion, to whether drug use in and of itself is enough to support termination. These cases, including a recent case out of this Court of Appeals, talks about the previous conduct, the 15 years of meth use he's had before, can't be used against him as a basis for termination. We got, as you say, it's got to be something that's happened once this case initiates. And there's a lot of cases out there that say, yeah, you don't have to actually injure the child. You don't have to have conduct that's directed at the child. But the question that I have for the court is, if I've never had this child in my possession for a day, the minute it was born, it was removed from me. If I go out and do meth every day after that, and this child has absolutely no contact with me, doesn't live with me, doesn't see me, doesn't travel with me, has no contact, how can my drug use endanger that child?
You're saying that there may be a different grounds for terminating your rights.
Certainly.
Under the code there, under 161, but not under E.
Not under E. They got him on O, maybe that would be a better ground. Maybe they get him on, this other case. If his rights got terminated on another child, maybe they use N or whatever it is to get him.
Was he terminated under O here?
Yes. He's terminated under E and O. Those are the only two grounds. So the endangering conduct, not even endangering environment, under D. They don't go that, the drug use, just because you're using drugs creates a dangerous environment. This is solely looking at his conduct.
So, but let me ask you that. Given that there was also an O ground finding, is your challenge here only to the E ground?
No. We challenged E, O, best interest, and the failure to grant the extension. The argument under O kind of ties into the failure to grant the extension, in that O, we're relying on the provision in the Family Code that says if you can't complete your services because of no fault of your own, then that cannot be a basis for termination. So that's the argument here, that he made a good faith effort, completed all this stuff, did this, and just an interesting twist on it that's in the record when you look at the de novo. There was an argument about whether OSAR required him to do the inpatient or not. When you got to the de novo, there'd been a second OSAR which only required him to do outpatient, which he was doing at the time of the de novo hearing.
Yeah, I'm glad you brought that up.
Your time is up.
May I finish?
Yes, sir.
I'm glad you brought that up. So, the court order that was signed or filed on March the 22nd, that court order was for the Padre program and for inpatient residential treatment.
Yes, sir.
Would a subsequent, he already had one OSAR, early March. Would a subsequent OSAR, that wouldn't have impacted a court order?
I guess as a technical matter, no. The order stands. It wasn't like there was a new order entered, or they said you don't have to do that anymore. There's nothing from the court that said that. But from a practical standpoint, if CPS says you don't have to go to inpatient, just do what OSAR says, I don't know what the right terminology is to use, other than it doesn't seem fair to terminate him for something that by the time you got to the termination trial, the CPS wasn't going to require anymore. Although the court order is there, it does stand.
Okay, thank you.
Thank you.
Thank you.
Good morning, and may it please the court. I'd like to start off with the extension denial, if I may, so we can go sort of in order. I think that makes the most sense. So, as we all know, under 263-401, the department has just 1 year to commence a trial on the merits on these sorts of cases, with a one-time 6-month extension. the move-in, in this case, would have had to prove extraordinary circumstances and that it was in the best interest of the child for the child to remain in the TMC of the department. And that's just not what we have here. Case law repeatedly tells us that actions which are the fault of the parent cannot constitute extraordinary circumstances.
Well, if the father's position is that he was required to maintain employment, and he also was required to complete this inpatient drug treatment, so is he supposed to choose which one to do, and then he's going to still be left with a service he didn't complete?
That's an important question, but it's not one that we have to even reach here, because he started inpatient and quit. That was his choice. So that is the very definition of his fault.
The one he quit, was that one that was, would have comported with the order?
I believe the order says inpatient, and I apologize, I can't remember the exact wording. I don't know if it says Synacor or Serenity. The important issue, I believe, is that he complete inpatient.
Yeah, it says inpatient
Okay.
residential treatment program at Synacor or at another similar substance abuse treatment facility.
Okay, so I guess the next question I have then is related to the timeline. I was unclear from Mr. Sharpie's answer whether this process of getting into a program and then dropping out was before or after the order was signed by the judge. Certainly in one case, if the judge says go and then you go and you drop out, maybe that indicates your intent to flout the order. The other way, if you don't have any knowledge that the order is being signed yet, that seems difficult to hold against him.
That is also an important question, and the record is simply unclear exactly when he started these issues. I will say that as far as other services that he was ordered to do, he was ordered to maintain a drug-free lifestyle, and he was ordered to submit to drug screens, and that was part of the court order, that was part of the service plan, and he simply did not do those things. There was nothing in the record that I can recall saying, you know, he attempted to go to these drug screens but couldn't because of employment or other issues. I believe his most recent missed test was in May of 2021, which is after he started employment, but I don't believe there's any testimony that says, you know, they were all in May after he got this job. I believe that they were sort of scattered throughout. And moreover, he admitted to using drugs during the case as late as May of 2021.
Well, that, and I wasn't trying to put words in your mouth, but I think that leads to the question that I was asking Mr. Sharpie just a minute ago, which was, without regard to this issue of inpatient rehab services, the fact that he continued to use drugs during this same time would have been mutually exclusive to being in an inpatient facility where you're not using drugs.
And yes, I would agree. I mean, if he's continuing to use drugs, which is, again, also his choice and also his fault, then that sort of snowballs with his failure to finish inpatient, which is, again, also his fault and not something that you can use to argue that the court abused its discretion in denying extraordinary circumstances. So, in addition, he argues about the Padre issue, and there is a portion in the record where he admits that at one point he contacted Padre. And so I believe that his argument at some point is that he didn't know the contact information for Padre, where he had already admitted he had it. Moreover, he did argue, you know, look, I have to go to work, which I understand, and, you know, it's hard to juggle everything, I get that, but he also said, completely admitted, he never asked his employer, hey, can you work with me? Can we move this around? And I might be remembering the transcript wrong, but from what I understand, he did, I'm sorry.
He never asked his employer, or he never offered any evidence that he asked his employer.
I believe he testified he never asked.
Okay.
So I could be corrected, but I'm fairly certain that's what he testified to, is he never asked his employer for any accommodation at all.
You acknowledge that that's kind of a tough dilemma to put somebody in, though, to simultaneously require inpatient rehab and a full-time employment?
I can understand how that would be problematic, but I believe in this case his argument was more about the Padre classes and employment as opposed to inpatient. I could be wrong,
Yeah.
but
He attended for a short period, for 5 or 6 days, the inpatient. That wasn't a problem with his employment at that time.
yes, Your Honor, yeah.
He didn't feel it was beneficial for him.
But that was before he began his new job. My point was, do you put the parent on the horns of a dilemma by telling them whichever one you choose, whether you choose inpatient rehabilitation or a full-time job, you're going to violate the other one by nature of your choice?
Well, does the service plan say full-time employment, or does it say gainful employment?
I don't know that off the top of my head. I apologize.
I may have just made that up. It does refer to employment.
It also
And he-
likely I'm sorry.
Yeah, and he did have a job, at least 2 jobs. Well, he was employed throughout the case, and I think that he testified that there was only a week that he didn't have full-time employment.
I believe you're correct. Yes, I believe he did have employment throughout the case and was able to shuffle it for inpatient earlier in the case, and then they made that voluntary decision to say, this isn't helping me, and so he left. So while I understand that could be an issue in some other case, that's simply not an issue.
Yeah, and I understand your argument that certainly there's other evidence of that the trial court got to take into account to determine the sincerity of his statement that he could not get inpatient rehab for that reason.
Is
Yes.
there some department policy that promotes a drug-free lifestyle over employment? Or
I'm not
vice
aware of
versa?
any, general policy. I mean, using methamphetamine is obviously a very serious barrier to being an effective parent.
Could be an effective barrier to employment.
Yes, Your Honor, it absolutely could. So I'm not aware of any policy that values one over the other. I mean, there are lots of things that go into making a person an effective and safe and stable parent. And I would argue that that's not just being clean, but also having, some ability to provide stability for the child.
Well, speaking of policies, what's the problem with granting an extension in this case? Why wouldn't it be, I mean, I know we're not going to substitute our judgment for that of the trial court, but what would be the problem with granting the extension? If you have a parent who's at least on his face making an effort to meet these requirements.
I believe there was some testimony from the CASA representative in that extraordinary circumstances portion saying how she had not seen any effort from these particular parents, I believe for the 2 months leading up to trial. And she states, like, look, I want to give these people more chances, but I am not convinced that they are actually taking this seriously or will actually move forward in this case. So I believe, that would definitely weigh in favor of not granting it to show that they're not actually making a good faith effort to move forward.
Would an
And-
extension of time have any effect over the court's jurisdiction, given the 1-year deadline? I think that's what you began your argument with a minute ago, which is, we've got 1 year to get a judgment in this case or to dismiss. This issue of we need additional time to see if this guy is going to work out in inpatient or not, does that go into the, at least the department's mind, on deciding whether to agree to that or not?
Well, in this the way 263-401 works, as long as we commence within a year, that satisfies. Or we can do the 6-month extension. But in order to get there, you have to satisfy, those requirements of 263-401. And in this case, the father was unable to properly argue that he could satisfy those requirements for that extension. So on this day, we timely commenced. So even without the extension, the court retained jurisdiction. Did that?
You timely commenced within the 1 year
Yeah, it's 1 year. The language of the
from the date of birth?
statute. Yeah, it's 1 year, or like the Monday following the 1 year that the department was named managing conservator.
Yeah, I wasn't raising the question of jurisdiction. I was asking the question of, does the timeline on jurisdiction go into influence the determination of whether the department agrees to an extension to allow something like inpatient rehab?
Well, Your Honor, I'm only an appellate attorney, so I've never been directly asked by a parent's attorney would I would I agree to that, and I would think it'd probably be on a case-by-case basis, whether or not that parent actually seemed serious about taking those steps to actually better themselves, where in this case, the parent definitely was not. He wasn't even doing outpatient at the first hearing. He waited until the second hearing to even start that. So that would be our issue there. And as for the best interest argument, I would point out that the appellant here is the movant in this case. So it's his burden to show that it's in the child's best interest to remain in the temporary managing conservatorship of the department while he continues to work on his services. And so here the trial court had the discretion to look at his history during the case and whether or not he was actually trying to work his services. And testimony indicated that for the 2 months leading up, he wasn't, he had sort of dropped out and, wasn't trying anymore. So the question then becomes, are we actually going to achieve anything by maintaining those extra 6 months? And the movement simply did not satisfy his burden in this particular case.
Is the department faulting him for not working his services during the time the paternity test was pending?
No, Your Honor. There was a specific order that stated he was not responsible for working his services unless and until the paternity test came through. So I'm not faulting him for that. But we do know that as early as January, he knew that he was the father. And, that I believe he even wrote it on his affidavit of indigency in January 18th, I believe, that he knew he was the father by then. And yet still we don't have much movement until March. So that's sort of the pattern for him. He has like this little burst of activity, or it does nothing, burst of activity, does nothing again. And during this time, he's continuing to use drugs, which likely weighs into the fact that he's not moving forward. But we have indications, in, I believe, an admission that he's continuing to use drugs as late as May, which is after he finished his other services, so it seems like he's clearly not taking this particularly seriously. Especially in light of the fact he does have that department history. I believe it's May of 2020, he has this other department case open because of methamphetamine. And he's still, knowing how serious this can be, continues to use methamphetamine with this child in this case, uses methamphetamine knowing that the mother is pregnant, uses methamphetamine with the mother while she's pregnant. So it's just sort of, altogether, it doesn't seem he's taking this fatherhood thing very seriously. So if I may move on to subsection E. So the appellant is sort of trying to boil this down to, just a little bit of behavior during this case and saying we can't consider his 15-year history, and cites to a variety of cases to support that. Those cases do not properly apply to this case, because this case, it's not just about he used to use drugs. It's not just that. It's he used to use drugs, and he continued to use drugs in this case, and he failed to finish his service plan, and he failed to maintain or even create a real bond with the child, because due to his own drug use and his own failure to engage, he didn't get visitation.
I think Mr. Sharpie's argument, though, it makes an interesting point, which is you have to focus on endangering conduct. And if I have no possession or access to the child during the time I'm using meth, then maybe there's another reason you can terminate me, but you can't terminate me on E grounds because you can't show that I've done anything that endangers the child.
There is, and I'm sure the court is very well aware of the bucket of case law that says under E, you don't have to commit these acts in the presence of the child. You can even do it before the child is born, and that still constitutes or can constitute E.
Do you think those cases are still good in light of the Supreme Court's more recent opinions on some of those issues?
I do, especially in cases like this where you can tie it all together. It's not just that he used drugs before the child was born. It's that he used drugs for 15 years, including after the child was born, and all these other issues. So all that taken together.
What inference does that allow us to draw about endangering conduct, though? The use of drugs in and of itself.
Well, I can say that there have been some cases, not that I know of referring to methamphetamine, but referring to PCP, that sort of do skirt around that issue. They don't come out and say, look, we all know PCP is dangerous, we don't have to talk about that, and that's not what I'm suggesting. But other courts have sort of acknowledged drug use in and of itself, these dangerous drugs create an unstable environment that exposes the child to instability, that exposes the child to the risk a parent will be incarcerated, that sort of thing. And that, you don't have to do that in the presence of the child in order for it to result in an endangering environment or, treatment of the child.
There are plenty of other sections under 161 that could be alleged. I think I don't want to speak for Justice Doss, but one of the frustrations that I have is that the department sometimes doesn't allege the obvious and tries to take one section and force it on a fact situation, and this may seem to be one of those cases.
Well, and my concern under D or E grounds are even more significant because that also affects future parenting roles when there could have been another way to terminate the parent's grounds, terminate the parent's rights on different grounds. When it says endangering conduct, how strictly do we construe the term endangering conduct, or do we really give the department a pass by saying, yeah, but it could have an effect, maybe in a metaphysical sense down the road at some point in the future, which in turn may affect the safety of the child.
And I can understand that concern about using E as sort of, or D as sort of a catch-all, but that's not really what happened in this case, because there was all this other behavior after the child was born. And again, it's to the cases that are cited by the appellant, it's not just one or two times that he used drugs before the child was born, we're not worried about it anymore, or, maybe he used during the case, but then he's, shown that he's rehabilitated. That's absolutely not what happened. He has a 15-year history of drug abuse. His oldest child, I believe, at the time of trial was 19, which would have meant that he started using drugs when that child was 4. And his second child, I think, was 5 at the time of trial, and this child, was 2, 3, somewhere in there. So despite being a parent for 19 years, he still decided to use methamphetamine for almost the entire time that he has been a parent. And he has shown that he is very unwilling to work towards sobriety because he quit inpatient. He hadn't even completed outpatient at the time of the de novo, which was months after he found out that he was the father. I mean, it was 10 months later. And he still had not rehabilitated himself or shown that he had. Still testing hot for drugs in July. And so that's the problem we have here. And I would also say that we did use another ground here. We used subsection O. So we weren't just trying to say that, you had some drugs and you didn't do the service plans, we're just going to stuff it all into subsection E. We also went under O because he did fail to complete his services. And under subsection O, if I could just very briefly address that, he does allege on appeal the affirmative defense under 161.001D, which we would state has not been preserved because he didn't plead it. And there's no trial amendment, he didn't say anything about it in pre or post filings, none of that. And so it wasn't preserved. But even if it was preserved, and if we are going to talk about the affirmative defense, he has to show an excuse why he failed each and every single one of those services. And he talks about the Padre service, but again, there is testimony that he had contacted Padre earlier in the case. So he had at some point some contact information for them. He failed to do inpatient, which again, that was his fault because he quit. And most importantly, he was ordered to maintain a drug-free lifestyle in order to submit to drug tests. And he didn't do that at all and hasn't presented any excuse on why he was unable to do that. So even if the affirmative defense is preserved, it doesn't really matter because he has not met his burden under that. I would just close by saying I don't really have anything to add under best interest besides what's in our brief. I would just point out that some of the cases that appellant does cite don't really work here because they refer to distant history or encourage this court to reweigh the evidence in this case, which is, as we all know, inappropriate and not what an appellate court is for.
Counsel, thank you very much.
Please the court. Got the record out. Let's try to clear up some of the questions that the court's got about what this is. I'm looking at page 27. This is with regard to the motion for extension. He's asked if he asked his employers to take off so he could complete. Previous to that, he had testified he'd never been unemployed for more than a week during the pendency of the case. He says, during my current job, I'm the only one there. There's no one to take my place whenever I'm not there. Those were his excuses. Also, there were questions about CASA, which I probably should have brought up, but if you look at page 30 of the record, CASA had filed a report recommending a 2-month extension. CASA was behind it. The judge said there was some confusion here, because at the time of the trial, he asked her about it, and she said, so it's just, I want to give them a chance, but I also don't know if they're worthy of a chance. So, one minute CASA's saying, maybe we should give them some more time, but she's going, I'm not sure, I'm not, in a position to make that decision. Also, we got questions about the Serenity Program and Padre. If you go to page 76 of the record, my client does testify. I did get hold of the Padre program. I was about to start it. That's whenever I'd gotten into Serenity in Plainview, I believe. I did go there. I was there for, I think, 5 or 6 days. I did leave early. Talks about why he didn't like it. He goes, I came back early and I had another OSAR with Linda Dudley, and she recommended me to do outpatient at that time, after that. I go, but you understand the order says you got to go inpatient, correct? He says, I was told that I was going to do OSAR, and whatever she said was going to be, was good. So, I understand from our perspective and our level of sophistication, we understand. And if the court orders something, it doesn't matter if the police officer tells you you don't have to do it. It doesn't matter if Ms. Savi tells you you don't have to do it. We know it's a court order, you got to do it. But let's have the context that we're dealing with here. He's dealing with the CPS agent. He's seeing the trial court once every 3 months, and probably ain't real clear what's going on when that's going on. He's dealing with the caseworker, and caseworker's telling him, go get another OSAR, because you can't go inpatient because you're working. I'm assuming it's not in the record, but Ms. Dudley, who's in charge of that, probably says, fine, you can go outpatient. He thinks that's it. He thinks he's done in the clear. Obviously, that's not the case. That's why we're here.
Well, he didn't complete outpatient either, did he?
No, he was in the process of the testimony at the de novo hearing was he was in outpatient at that.
He started it after the September hearing, and then...
I don't think the record's exactly clear when he started it, but here's the point on the motion for extension, Justice Parker. Most people have to start their services after the adversarial hearing. They got 12 months to do it. This guy didn't have to start working services until January. At September, October, November, December, he wasn't even required. He lost 4 months there. Then he gets started late in January, but he gets most of it done till March. And then we've got the order entered to go inpatient, and he's got 4 or 5 months to get that done. Says he can't do it. If you look at the statute on the extension, section B2 of that section, specifically says the court needs to consider in whether to grant the extension if inpatient substance abuse has been ordered. The legislature anticipates that type of situation, because we all know that's a huge burden. I mean, I'm not trying to be facetious, but it'd be real hard for me to just shut down my practice for 30 days and go sit down there in inpatient rehab. It's a heavy burden. Not that it's not merited. Not that it should...
Let me ask this then, because this is... We're dealing with an abuse of discretion standard on appeal.
Yes, we are.
And what I have observed in a bunch of recent termination cases is a similar situation where parent shows up the day of hearing and says, hold on, you can't have this hearing. I need additional time because I need to go try out inpatient rehab. So stay all of this and give me time.
The typical argument is, I'm sorry to interrupt, Justice, but
No, you're
they don't take it seriously till they're there. Like, oh, I didn't know this was really going to happen.
Yeah, they see the shadow of the courthouse, and something happens, or
Yeah.
angels descend on. Whatever
Yeah.
it is, they have an awakening at that point that that's what they need to do.
I think the issue for the court is real simple on the extraordinary circumstances.
How do we assess the trial court's exercise of discretion under those circumstances that we, and maybe we say that's a trial court problem. Maybe we say it's a trial court problem to determine the sincerity of every person who appears before them on whether this is something they are using for legitimate reasons or merely a stalling tactic.
Yeah, I don't think we can get into the issue of whether the trial court's judge of the credibility of the witness wouldn't it be a basis for reversing. I think it's real simple. There's cases that say giving them 15 days to work services is abuse of discretion to deny the extension. Only giving them 30 days, there's cases that say that's an abuse of discretion. Here, it's 5 months. Normally you got 12. This guy had 5 months. I'll admit it, he had excuses why he couldn't get it done, but is it an abuse of discretion to not give him more than 5 months? That's what it boils down to from my perspective.
Counsel, thank you very much for
Thank
your
you.
arguments. This case will be submitted on the briefs. Normally, we do not announce from the bench when you might anticipate a ruling, but I can predict that you'll have a ruling before the end of May because I'm retiring, and today is my last day on the bench. Really? This will be the last time I appear on the bench, but I won't be retiring officially till May 31st. So if I'm going to participate in the final opinion, we're gonna push it forward and get it out before May 31st. But Mike, particularly, you practiced for me for a long time. So you know, put that on your. So anyway, thank you very much for your presentations, and we'll be in recess.